Hi, everybody. My name is Al Saikali, and I chair the Privacy and Data Security practice at Shook, Hardy & Bacon. Joining me on this webinar is Colman McCarthy, an associate in our Kansas City office in the area of privacy and data security, who leads our CCPA task force. On today's webinar, we're going to be talking about the recent amendments to the California Consumer Privacy Act. As we record this webinar, the California legislative session has just ended, and so the purpose of this webinar is to give you an update on the different bills, to let you know which ones passed and which ones didn't, and what the significance is for the bills that did pass through the legislature. We still are awaiting the governor's signature on these amendments, but assuming that does occur, then this webinar will explain for you some of the operational consequences of the passage of these new amendments to the CCPA.
Thanks, Al. Welcome, everybody, to our little webinar. As Al said, my name is Colman McCarthy. I'm an associate in Kansas City, focusing on data privacy and security. And I've, been doing a lot of looking at the CCPA over the past few months, as I'm sure many people have done. There's been a lot of ups and downs in the California legislative session this year as to, what bills were introduced, which kind of fell along the wayside, and which finally made it over the finish line, so to speak. So among the bills that we've been looking at, there were kind of 8 that made it to the last steps. 6 finally passed both houses of the California legislature, and 2 just kind of stumbled right at the end. And we're going to be talking about all of those and some quick notes on other bills that were introduced. We have, Governor Newsom has about a month to sign the bills that were passed. So we're almost to the finish line, but not quite there yet. And we're going to kind of get into the specifics of what's gone on. But first, we're going to just give a quick update on, the regulatory activity that's been going on with regard to the CCPA, because the CCPA does include a provision that kind of lays out certain things the Attorney General's office has to engage in rulemaking on. As of right now, there's nothing really to report. We're not really expecting any preliminary rulemaking activity. We weren't expecting it before the legislative session ended because, the final form of the CCPA wasn't complete. So we think the AG's office is kind of waiting to see what the final form of the amendments took. We do expect some preliminary rulemaking activity in the next few months, but that probably means that final regulations are not going to come out until next year. So, it's our current expectation that Attorney General enforcement is not going to will not begin any earlier than July 2020, which is the kind of the deadline the CCPA set for the AG to start enforcement activity. And it could have been as early as January 1st, but that was kind of dependent on rules getting put out ahead of schedule, and we're not seeing that. So our current thinking is that AG enforcement probably going to start in July of 2020. And, if you have more questions on what the AG is doing and kind of that activity, you can definitely reach out to us, and especially if you want to reach out to Steve Yu. He stays on top of this and really has the knowledge if you have any questions. Next, we're just going to kind of cover briefly all the bills that got introduced earlier this year that fell along the wayside for one reason or another. They died in committee or were pulled by the author. I'll just say up front here that we call these bills inactive rather than dead, just kind of due to the fact that California legislature has a 2-year legislative session. So even though these bills, fell off early on and for all intents and purposes are dead, they are technically alive and can be revived next year. So that's why we call them inactive instead of dead. And, just to kind of touch on these quickly, probably most notably SB 561 and its close relative AB 1760 Both of those bills would have created a private right of action for any violation of the CCPA, and these bills were being very closely watched at the beginning of the year when they were introduced, because currently the CCPA only provides a private right of action for data breaches in certain situations, but no private right of action for broader violations of the CCPA in general. Now, there are arguments out there that there will be other ways for plaintiffs to bring cases for violations of the CCPA, such as under the California Constitution. But these two bills would have explicitly added that right. So the fact that they were basically defeated earlier in the year is kind of a major occurrence. And also, AB 1760, it also would have required opt-in consent in certain situations. And right now, the CCPA is only requiring opt-in consent for minors if a business wants to sell the personal information of a minor. Another bill that would have had a major impact was AB 950, and that's the one that would have required businesses to disclose the average monetary value of consumers' personal information by posting that value on its website. And I mean, it's easy to see how that could have been a compliance nightmare, because what is the monetary value of a consumer's personal information? So that bill was also, defeated quite early on. Other bills that didn't make it, SB 753, which would have removed the do not sell link requirement, the requirement to provide that DNS button, that DNS link to allow people to opt out of the sale of personal information. AB 873 would have explained that de-identified information must not be reasonably linkable to an individual. That was adding the word reasonably in that formulation. AB 288 would have allowed social media users to have their personal information permanently removed from a social media company's database after the user closes their account. AB 1416 would have provided an exception to businesses that release consumers' personal information to government agencies for the purposes of carrying out a government program, and that bill was seen as quite a potentially large loophole in the CCPA. So there were quite strong objections to that bill, which is probably why it didn't make it all the way. And then AB 981 would have provided a broad carve out for insurance transactions by taking away consumers' right to request her personal information be deleted from a database or not sold if the information could later be used to complete an insurance transaction. And there was also a bit of controversy about this one because there were people who thought that it would end up being too broad of an exemption for insurance companies to keep and use personal information, and that's why it was defeated. Moving on, we're going to talk really quickly about the two bills that we're keeping a close eye on that, at first it looked like they were also going to pass the legislature, but they, at the very last minute, they stumbled and didn't quite get across the finish line. And the first of those was AB 846, and that was the bill that would have clarified the CCPA's application to customer loyalty programs. That's not to say that they're not allowed under the current language of the CCPA. It's just there's confusion over how providing a customer loyalty program interacts with the right against the right to non-discrimination. And this bill was kind of intended to clarify how that plays together, and would have allowed, would have said that these programs are entirely permissible with the consumer's voluntary participation. And the reason that this bill likely failed at the last minute is put on the inactive file and there's plans to reintroduce it last year. But the reason there was kind of this last-minute hiccup was, a late amendment tried to allow the sale of personal information collected as part of these programs in certain circumstances, whereas the previous version of the bill had put a flat prohibition on selling that information. And adding that amendment led to some controversy, and that's probably why it was pulled at the last minute. As far as AB 1138, that's the bill that would have required parental consent for minors to use social media. And this, when you first hear that, you'd think it would probably be non-controversial, but there was some controversy because, there are concerns for impact on LGBTQ youth who may be living in a household where, they have conflict with their parents, and having a safe space online is important for these youth, and having to go through parental consent to get to that safe space could put those youths in a bad situation. That's why there was controversy. It failed the final assembly vote, mostly because there were a lot of members who did not actually register a vote. Reconsideration was granted, which means that this bill will still be alive for next year and kind of in the same position in that final step for final assembly vote. So we'll see next year whether it's resurrected and re-voted on and passed at that time. But hey, yay! We've finally made it to the point where we get to talk about the 6 bills that actually passed the California legislature and are on their way to actually being enacted into law. But I think first we're going to take a couple minutes here. I'm going to turn it back over to Al. He's going to discuss a pretty important bill that actually was also passed by the legislature, AB 1130. So I'm going to turn it over to Al now.
Thanks, Colman. Yeah, so this isn't one of the CCPA amendments that a lot of people were watching, and it sort of snuck in there, and I don't think many people really understand the significance of the consequence of this and what it could mean. But AB 1130 adds a couple of data elements to the state's data breach notification law's definition of personal information. It adds things like passport number. It was as a result of the Marriott incident, and it also adds, importantly, biometric information. So if you have a data breach of biometric information, there's now an obligation to provide notice of it. That's not as significant in itself. What makes it significant is that the private right of action for data breaches under the CCPA, that uses the definition of personal information, not from the CCPA, but from the data breach notification law. And also importantly, the CCPA defines a data breach differently than the data breach notification law does. It's broader under the CCPA. It includes unauthorized disclosure of what would ultimately be biometric information because it's using the definition of personal information under the data breach notification law. So the unauthorized disclosure of biometric information can result in a private right of action under the CCPA as it will now stand with 1130 passing. Now, what does that mean as a practical matter? Why is that significant? What we've seen with a lot of the BIPA cases that we're handling is that there are many companies that use timekeeping devices that require finger scans in order for employees to check in and out of work. Sometimes information may be stored locally on the devices. Sometimes it may be shared with a third party. And so there are allegations in these cases that when the information is stored on servers that is outside of the employer, then that is an unauthorized disclosure of biometric information. So many of these companies, which have been hit with these counts of unauthorized disclosure under the Illinois BIPA litigation, are now going to be subject to the same thing in California. So what's the takeaway from all of this? If you are a company that collects biometric information or may be using biometric information and uses some of the cloud service provider services or stores the information with the provider of the biometric technology provider, you need to look out for this as a possible risk. So it's out there. I would expect that plaintiffs' lawyers will start using that as a theory for liability moving forward. And so, in essence, this means that California does have a small form of a BIPA law now in place that companies need to be concerned about. Now, look, I don't want to overly scare anyone. There are some strong reasons why these kind of cases still should not proceed. I mean, one argument is that it's not a disclosure, it's a transmission, and that argument's being made in the Illinois litigation and being litigated over, and some courts agree with that and some courts haven't. There's also an argument of, well, that's not really what a breach is meant to be. It's supposed to be an unauthorized actor who really gets in and acquires or accesses the information. So we'll see, but, the right plaintiff's firm and the wrong courts can result in significant potential liability. So that's the update on AB 1130, and that is also waiting for the governor's signature. And Colman, I'll turn it back to you.
Thanks, Al. The first bill that we're going to talk about, kind of like AB 1130, also actually is not part of the CCPA, but does draw heavily from it and is kind of integrated with. So, we have been tracking it, and this is AB 1202. This is the bill that requires data brokers to register yearly, to pay a registration fee and provide some basic information. Now, the definition of data broker under this new law is someone who knowingly collects and sells personal information of consumers that they don't have a direct relationship with. And on the face of that could seem kind of broad, but the real kicker here is what is a direct relationship? What does that mean? And that's kind of the big takeaway from this bill, because when you look at the legislative findings section of this new law, it gives an example of direct relationship of a consumer affirmatively and intentionally interacting with the business's online advertisements. And that, if you consider somebody clicking on your ads as a form of direct relationship, that can really, narrow the coverage of who is a data broker. So in the end, we're not quite sure how expansive this law is going to be and to how many businesses it's going to apply. But, it was a significant bill, and it is something that people need to be aware of. Also, the bill does provide some carve-outs for credit reporting agencies, financial institutions, and insurance companies to the extent they're covered by FCRA, GLEBA, or the Insurance Information and Privacy Protection Act in California, respectively. This language, to the extent covered by, that kind of puts it in the same realm as the other exemptions from CCPA that we see for HIPAA and GLIBA. That it's not a company-wide exemption or exception. It's more focused on the information that is actually covered by those laws. As far as penalties, penalties can be $100 per day plus registration fees and AG costs. So not a huge amount, but not something to just sniff at. The new title added by this law is 1.A1.48, and it's adding 4 sections to the law. AB 1146, this is the law that is going to make life a little bit easier for car dealers and manufacturers. This bill is providing an exemption for certain narrow categories of information, such as VIN, make, model, names and contact information. This is allowing new car dealers and vehicle manufacturers to retain and share these types of information with each other for the purposes of warranty or recall repairs. It's also providing another exception to the right to delete in the case of needing the information to fulfill the terms of a written warranty or product recall. So, there's for new car dealers and manufacturers, there's going to be less uncertainty about what they can and can't do with a certain subset of information where, beforehand, as with anything CCPA, there was going to be gray areas and difficulty in understanding exactly where and what can be done. This provision is modifying existing sections of the CCPA, sections 105 and section 145. In AB 1564, this bill is modifying section 130 of the CCPA that has, the requirements for your online privacy policy and the requirements for responding to consumer requests. And section 130 also talks about, the types of methods of submitting consumer requests that a business has to provide. And what this bill is basically doing is it's providing this third option for a business who is exclusively online and has direct relationships with the consumer. That type of business only has to provide an email address for consumers to submit requests. And, we see that terminology, again, direct relationship, and, what is that going to mean? And in the end, are there going to be more businesses who can take advantage of this and just provide the email address? Because otherwise, the CCPA is still going to require two or more methods of allowing consumers to submit requests, and with providing a toll-free number at a minimum. And if you have a website address, you have to make that website available to consumers to submit requests. And one of the takeaways here is, what does it mean to make your website available to consumers to submit requests, right? Does that require that you provide an online form? Or does it just mean that you put an email link on your website that people can click on to send in an email? So, this bill may or may not have clarified what you need to do to provide these methods of request. I think in most cases, most businesses are going to have, both consumers who they have a direct relationship with and consumers that they don't. So, in the end, practically speaking, it's probably just going to be safer to provide a toll-free number and then, look at your website address to see what else you are providing, whether it's an online form or email. Moving on, we're going to talk about AB 1355, which kind of turned into the omnibus error correcting bill. I think at the beginning of the process, many people thought AB 25 was going to handle that role, but in the end, it kind of fell to AB 1355. So, just some of the errors that it's corrected in the section where where the CCPA requires certain disclosures in your online privacy policy. It originally said that you needed to disclose specific pieces of information, which didn't make any sense. So AB 1355 says instead you just have to disclose that a consumer has the right to request those specific pieces of information. Another error that it's correcting is in the right to opt out, where, below the age of 16, you need to get opt-in consent for minors, whether it's from the minor, him or herself, or the parent or legal guardian. And the language in that section was just a little, not clear as to, the exact age limits, whether 16-year-olds were included or not, and whatnot. So AB 1355 just clarifies that language. Also, in the right to non-discrimination, originally it said that, notwithstanding that, you're not supposed to charge a different rate or provide a different level of service, you could, if the different price was reasonably related to the value of the consumer data to the consumer. And that's what the CCPA did say. And that was, it was a bit confusing, and it was going to be tough. What does it mean? How do you measure the value of the data to the consumer, him or herself? So what one of the things AB 1355 does is just clarify that we're talking about the value of the consumer data to the business, which is a little bit easier to determine, and that will allow you to charge a different price if there is that reasonable relation. And then another one of the major errors that it corrected, that this bill corrects, is in the data breach right of private right of action. Previously, just based on the way what language was used, and some weird double negatives, it came out to that the safe harbor meant that you had to both encrypt and redact data before you would have that safe harbor from the private right of action. And there's just a tiny little correction where now the data can be encrypted or redacted, and you'll still be able to take advantage of that safe harbor. Now, beyond just doing corrections, AB 1355 does have a couple of substantive additions, and one of the big ones is there's now going to be a one-year carve-out for personal information of consumers in their role as business representatives. Now, this is going to be a pretty constrained and limited carve-out or exemption. It will sunset on January 1st, 2021. Opt-out and non-discrimination rights still apply, and this exemption is only going to apply basically when you have an existing relationship with someone. So it probably won't cover the situation where you're cold calling someone at a business just in the first instance. So there has to be some pre-existing relationship where now you're communicating with the person and collecting information in the context of providing a product or service. And then the other substantive change that AB 1355 is making is that there was already an exemption for certain FCRA activity, and AB 1355 is kind of broadening the scope of that exemption to more activity if that activity is authorized by the FCRA. So before it wasn't very clear to what extent that FCRA exemption applied, and it was only when you were selling information to or from a consumer reporting agency. So now there's going to be more activity swept in if it's authorized by the FCRA. And AB 1355 is it's modifying a number of provisions in the CCPA, almost too many to list. So, but it's got a pretty broad reach, and was one of the more impactful bills that we saw. And moving on, we come to AB 874. Also, though more of a shorter bill, very impactful as well, because this bill is touching on the definition of personal information. And as we all know, the definition of personal information in the CCPA is probably the broadest in the world and the farthest reaching, and probably the most important change that AB 874 is adding this term reasonably in front of the formulation capable of being associated with an individual or household. Before, the definition of personal information was kind of drawing this bright line that, if you were reading the statute strictly, would sweep in any type of situation that you could dream up where, even if it took you 10 steps, if something was capable of being associated with an individual household, then it was personal information. AB 874, by adding this term reasonably in, is backing away from that draconian definition of personal information. On the flip side, though, as we all know, the term reasonable or reasonableness or reasonably is mushy and uncertain. So, what the scope of the definition of personal information is going to be now is going to be grayer, but it will allow some more flexibility in compliance with the CCPA. Now, AB 874 was also corrected an error, well, what was widely perceived as an error, because in the definition of personal information, you get to this term publicly available. That term has been clarified itself by making it much simpler. But then you came to this part where it said publicly available did not include de-identified or aggregate consumer information. And I think almost universally people looked at that and thought it was an error, and it should have said personal information does not include de-identified or aggregate consumer information. In AB 874, which is modifying Section 140 that has all the definitions, AB 874 corrects that so that it's clear now that de-identified or aggregate information is not personal information. And now we get to the final bill we're going to talk about, AB 825, which I think was probably the most closely watched, most anticipated bill because it has the potential to have the widest ranging effect. And this is the exemption for personal information of job applicants, employees, owners, directors, officers, medical staff members, or contractors. When you collect that information solely within the context of that person's role as an applicant or employee, we didn't have the space on this slide to cover it, but there's also similar exemptions when you're talking about emergency contact information or administering benefits. So it's employee information, it's emergency contact information, it's administering benefits. So when you're collecting that information in those specific contexts, there's going to be an exemption from the CCPA generally, but businesses still have to provide the notice in Section 100B, and that notice is you have to disclose at or before the point of collection the categories of personal information you're collecting and the purposes for that collection. So there is still some disclosure that you'll have to make to job applicants and employees and contractors, but it's much more limited than the type of disclosures that you have to make under the CCPA, in your online privacy notice when you're talking about categories of information, categories of sources of information, who you've disclosed the information to for a business purpose, all these things. So it's a much more limited disclosure obligation. This exemption is also not touching on the private right of action for data breaches. So employee personal information, if it's involved in a data breach, there'd still be the private right of action that applies to that. And this bill also is sunsetting after a year, and what that means is the exemption will begin on January 1st, 2020, and this information will be exempted throughout 2020 because privacy advocates and business advocates had disagreements about this bill, and the compromise was that they would provide a year where it was in effect and try to work out a different compromise that would satisfy people on both sides of the issue. So for 2020, this exemption will be in effect, where personal information of employees, etc., will not be covered by the CCPA more generally. But if no other compromise is reached and no extension of the bill happens, on January 1st, 2021, these people, employees, job applicants, and others, their personal information will become fully subject to the CCPA. Now,
Colman, go ahead. Sorry, finish that, and then I was going to say that just one thing to add there, that we have developed some templates particularly for mid-sized and smaller companies to use to help provide the notice that is going to be required with respect to employee information. And of course, people can get directly in touch with you in order to talk about using that template as part of developing either a more fulsome privacy notice for employees or as a starting point for providing notice generally. That's
a great point, Al. Thanks for reminding me of that. If you want, you can reach out to us. As Al said, we have those things in the works, so please do reach out if you're interested. And just to cover a couple more points about AB 25, it was doing some changes beyond just the employee information exemption. There's a change that allows businesses to require reasonable verification of consumers when they submit a consumer request. I think before it was kind of this unstated understanding that businesses would be able to, require verification. Now it is explicit in the CCPA. And then also another change is that if a consumer has a pre-existing account with the business, such as an online account, a business may require that person to submit requests through that account. Notwithstanding the provision about having to have a toll-free number and a website address. Where the consumer has a pre-existing account, you can make them go through that account to submit the request. And AB 25, the sections that this bill is adjusting are sections 130 and 145. And section 145 generally has the defenses and exemptions to the CCPA. And that's it for us covering the bills, at least, for our presentation on that. And, we like to be funny. In the previous incarnation of this presentation, we had a joke, but, it's just not fun to repeat jokes, so we had a little trouble coming up with this. So we're just going to assume, and have you assume with us, that we said something incredibly funny, we all laughed, and we can move on from there. And this is the point of the presentation where we normally have Q&A. Obviously, since this is pre-recorded, we can't do that. If you do have questions, please feel free to reach out to us. Myself, Al, anyone on our team, we're happy to answer questions. But we have gotten some questions that we thought we could address here quickly, just because they can be common questions, and we thought we'd just try and cover them here. So one of the questions is, what are these bills adding? Are they adding new sections to the CCPA? Because over the past year, we've all kind of been getting used to which section is which and does what. For the most part, these bills are not adding new sections to the CCPA. They're just modifying language. AB 1202, which is not technically part of the CCPA, is adding new sections. AB 874 would have added a new section to the CCPA, and if it gets revived next year, that could happen. But for right now, no new sections have been added to the CCPA. Another question that we've gotten is, when we're talking about the designated methods for submitting requests, the question is, are those requirements just applying to the right of access under sections 110 and 115? And on the face of the CCPA and AB 1564, which is addressing consumer requests, yes, those consumer request methods are just for the right of access under those two sections, but that's just, a strict reading of the CCPA. When we think realistically, consumers are going to be submitting other types of requests. And, practically, operationally, realistically, the same methods that you're providing for the right of access, you're probably just going to provide that for the other types of requests anyway. So, even though the law is only applying to the right of access in this situation, realistically, it's going to cover all the rights. Another question that we've gotten is, kind of what's the boundary of this reasonably capable language in the definition of personal information? What's not reasonably capable of being associated with an individual or household? For example, if you're collecting IP addresses or cookies, and that's not including any direct identifiers, right? Are those reasonably capable of being associated? And unfortunately, especially at this point, there's no clear answer. Other than to kind of say the harder it is or the more steps it takes to associate that information, the less likely that it would be seen as reasonably capable of being associated with. It's probably going to take a case-by-case analysis for the different, data types that you're collecting. But we think if you act in good faith, right, and it's probably a good idea to document your decisions. But if you're not trying to kind of play fast and loose with the rules and work things to your advantage, I think the AG is probably going to be pretty reasonable, at least at first, until we have more guidance on what is included and reasonably capable of being associated. Act reasonably, act in good faith, and remember that the CCPA has a provision that explicitly says that the statute has to be liberally construed to effectuate its purposes. So, when you get to a situation where the answer is not clear, it's probably safer to take a conservative approach and call it personal information. Moving on, another question that we've gotten is what's the interaction of AB 1355's requirement to provide a telephone number for consumer requests and other methods? What's the interaction with AB 25, which allows businesses to require account holders to make requests through their account? And I kind of covered this a little bit earlier, but just to be a little more explicit about it, these bills and their changes, they're going to be overlapping, but they're not mutually exclusive, right? Even for businesses whose customers can create accounts, those businesses are probably still going to collect information from consumers who don't have accounts. Right. So for those consumers who don't have accounts, you'll need to provide the telephone number, and the website or some, whatever other methods you're providing, even though you'll have the ability to require certain customers use their accounts. Right. So, it's probably going to end up that you'll have to provide the telephone number, right? At the same time, in certain situations, you'll be able to require people to use their accounts. So, those two bills overlap, but they're not really creating that much conflict in most use case scenarios.
And just a couple other quick questions that we've received as well on the CCPA. One question is about the AG's regulations. When are we expecting them to issue some sort of guidance on the CCPA? There's a number of matters that the AG is supposed to issue some guidance on, and the short answer is we don't know, but it is generally expected that it'll be released before the end of the year and perhaps within the next month or two. So we are obviously on the lookout for that, and we'll produce a separate webinar once that's issued to provide more guidance to our privacy clients on that topic. The second question that we're getting is, there's no private right of action under at least a statutory private right of action for the privacy violations under the CCPA. But, what will that litigation environment look like moving forward? And I would not be surprised at all to see entrepreneurial plaintiffs' lawyers filing lawsuits making negligence claims for the same behavior that is prohibited by the CCPA and using the CCPA as a measurement of what is considered reasonable behavior. So it would be a common law count of negligence, but it would use the statute as a measurement of what is reasonable behavior. And I could see them trying to push those sort of theories next year as well, but we'll see. Maybe that might be perceived as getting too far ahead of their skis, and I think they'll have plenty to be able to do with just the private right of action for data breaches, because keep in mind that the Attorney General's office posts on its website all of the breach notification letters that it receives. So that'll just be a trough of information for the plaintiff's bar to dig through and find potential defendants in class action lawsuits. So with that, I just want to wrap up the webinar and thank Colman for staying on this and sending you all weekly updates on the developments in the CCPA amendments. You see in front of you some pictures of our team, our core privacy team at Shook. And so please feel free to reach out to any of us if you have questions about the CCPA. Colman, any sort of closing thoughts?
Thanks, Al. Yeah, as you know, we all know the CCPA has been, the biggest development in U.S. privacy law in some time, and we're all pretty well aware that it has this broad reach. It's on par with the GDPR in Europe. It has these broad effects and can be very difficult to comply with, and especially when you get into those really specific scenarios where specific to your business, you need to know how to comply. Unfortunately, many times the answer is nobody really knows. Things will become clearer as the law ages, of course, but right now, everybody has questions. And, we're here to help. If you have these questions about these specific scenarios or just the CCPA in general, we're available. We're always here to talk and help you through those questions. So please reach out to us. And thank you again for making our little webinar so great. We appreciate you attending and listening. And we hope to be able to provide more content like this in the future. So with that, thank you and have a great day.